Finally, we come down to the heart of negotiable instruments, the questions of liability, defenses, and discharge. So the transfer of negotiable instruments raises a number of questions. For instance, what liability does a signer of a negotiable instrument have? What representations are made when someone endorses a negotiable instrument? What defenses are there to claim on a negotiable instrument? And when are the responsibilities associated with the negotiable instrument discharged? So today we're going to look at liability, defenses, and discharge of negotiable instruments. And after this lecture, you should be able to answer the following questions. First of all, what information is needed to determine signature liability? What is warranty liability? And how does one avoid liability for negotiable instruments? And finally, when is responsibility on a negotiable instrument discharged? Now, we know that liability can arise from signing a negotiable instrument. And in fact, signature liability is the essence of negotiable instrument law. Signature liability relates to signatures on instruments. Those who sign negotiable instruments are potentially liable for payment for the amount stated on the instrument. Now, there are two kinds of liability associated with negotiable instruments. There is signature liability, which we just described, and there's also warranty liability. Warranty liability is liability that's going to extend to both signers and non-signers. A breach of warranty can occur whenever the instrument is transferred or negotiated. Now, signature liability means that every party who signs a negotiable instrument may be liable for payment of that instrument. And as we noted, signature liability is the essence of negotiable instrument law. Once it is established that a party signed an instrument, the UCC will define that liability of the signer. The only exception being a qualified endorser. So we know that ordinarily the UCC is going to govern the liability of anyone who has signed a negotiable instrument. Now, there are two types of signature liability. The first is called primary liability. Primary liability is an absolute requirement to pay a negotiable instrument upon presentment. So it's an absolute requirement, subject to a valid defense, of course, to pay a negotiable instrument upon presentment. A person who is primarily liable is required to pay the instrument subject to any valid defenses. Now, a maker of a note is primarily liable for payment of a negotiable instrument. In the same way, the issuer of a cashier's check is also primarily liable on the instrument. So whoever makes the note has primary liability for the instrument. And finally, an acceptor also has primary liability. Remember, an acceptor is a drawee who has, by signing an instrument, agreed to pay it when it is presented for payment. Now, a person who is primarily liable is required to pay the instrument. The maker must pay, subject to certain defenses. And if an instrument is incomplete when the maker signs it, then the maker's obligation is to pay it as completed. So this is to encourage makers not to sign an incomplete obligation. Otherwise, their obligation is going to be to pay as completed. Secondary liability is triggered by dishonor of the instrument. So failure by either a maker to pay on presentment constitutes a dishonor of the instrument. I should say failure by either maker or acceptor to pay on presentment. So dishonor occurs in the following circumstances: when payment is refused, when payment cannot be obtained, when the instrument is not paid, or mere delay in payment does not necessarily constitute dishonor. Now, to hold a maker primarily liable for dishonor, they must receive proper notice of dishonor. And notice can be given in any reasonable manner. Secondary liability is a contingent requirement to pay a negotiable instrument, meaning secondary liability does not arise until there has been a failure on the part of the maker or the part of the person who is primarily liable to pay the instrument. So that's when we get secondary liability. That means that now the holder of the instrument can look to others for payment of the instrument. Drawers and endorsers have secondary liability. So when you endorse a note or a draft, a check, you are creating liability on your part if in fact the maker of the note or the drawer of the check does not follow through. Dishonor of an instrument triggers the liability of parties who are secondarily liable on the instrument. So when it is dishonored, the parties that are secondarily liable become liable for payment. Secondary liability arises only when the following are present. First of all, the instrument is properly and timely presented. It is dishonored, meaning it's not paid, and timely notice of the dishonor is given. Remember, presentment occurs when a person presents an instrument to the party liable on the note to collect payment. Signature liability requires timely presentment to the proper party by an authorized method. Now, who is the proper party? The proper party in this case is the party to whom presentment must be made, depending on the type of instrument. So for a note or a certificate of deposit, the maker is the proper party to whom presentment must be made, the party who signed the note originally, who made the promise to pay. A draft must be presented to the drawee for payment, acceptance, or both, the drawee being the bank ordinarily. Authorized method. An instrument may be properly presented by any commercially reasonable means, whatever is reasonable under the circumstances, or through a clearinghouse used by banks, or at the place specified in the instrument. So we need to present the proper party using an authorized method, and it must be a timely presentment. To hold the signer liable, the following requirements have to be met. Again, presentment occurs when a person presents an instrument to the party liable on the note to collect payment. A time instrument must be presented for payment on its due date. A demand instrument must be presented for payment within a reasonable time after its issue. And a check should be presented for payment within 30 days of its date or the date that it was endorsed. Remember, notice of dishonor must be given in a reasonable manner and within a reasonable time. How does one person sign for another person or company? Well, we need to revisit rules regarding principal and agency. An agent is a person who agrees to represent or act on the part of a principal. An authorized agent can bind his principal on an instrument by signing the instrument in such a way as to clearly show that he is signing on behalf of the principal. In that case, the principal, rather than the agent, will be liable on the instrument. Now, principal is a person who agrees to have an agent act on his behalf. So an authorized agent can bind his principal on an instrument without making himself liable. Now, it's possible that both the agent and the principal can be liable on the instrument. If an agent signs both on behalf of his principal and on behalf of himself individually, then both the agent and principal are liable on the instrument. It is even possible for the agent to be liable but not the principal if an agent signs without the authority to do so. If the agent did not have authority to sign a document on behalf of the principal, then the agent will be liable but not the principal, despite, however, their relationship is characterized. Now, there are rules for unauthorized endorsements. We know that a forged or an unauthorized signature does not bind the person whose name is forged. So if someone forges your name to an instrument, you cannot be held responsible for that. An unauthorized signature will bind the person whose name is forged if, however, that person ratifies or affirms the obligation, or that person's own negligence substantially contributed to the forgery. An unauthorized signature operates as the signature of the unauthorized signer in favor of a holder in due course. So an unauthorized signature can operate as the signature of the unauthorized signer. That's his sign, even though he is using a different name. Now, there are rules for unauthorized endorsements. Ordinarily, the first party to accept an instrument bearing an unauthorized endorsement bears the risk of loss. So say your note or your draft is endorsed with an unauthorized signature. The first party to accept that instrument then will bear the risk of loss of it not being paid. An unauthorized endorsement will not bind the maker or drawer except in very limited circumstances. Now, there's also the imposter rule. An imposter rule says that when an imposter induces the maker or drawer to issue the instrument to the imposter, a loss would fall on a drawer or a maker when an imposter induces the maker to issue that instrument for the imposter. The fictitious payee rule states that when a person causes an instrument to be issued to a payee, when in fact he will have no interest in the instrument. So remember the general rule that the first party to accept an instrument bearing an unauthorized endorsement will bear the burden of loss. When a party transfers a negotiable instrument through negotiation, that party, the transferor, is going to create implied warranties. There will be implied warranties attached to that transfer. And there are two types of warranties that apply to the transfer of negotiable instruments. The first is called a transfer warranty, and the second is a presentment warranty. Let's talk about each of those in more detail, starting with a transfer warranty. So any person who transfers an instrument for consideration, meaning you must get paid in order to transfer the instrument. This does away with gifts and bequests. Any person who transfers an instrument for consideration warrants items to subsequent transferees. And those items include: 1, the transferor is entitled to enforce the instrument, that all signatures are authorized and authentic, that the instrument itself has not been altered, that the instrument is not subject to a defense or claim of any party that can be asserted against the transferor, and the transferor has no knowledge of any insolvency proceedings against the maker or the acceptor or the drawer of the instrument. So whenever a negotiable instrument is transferred, these transfer warranties are attached to that transfer, meaning if any of these are not true, then the transferor has breached the transfer warranty. Transfer by endorsement and delivery of an order instrument extends warranty liability to any subsequent holder, meaning you are warranting those elements even to subsequent holders, not just the initial transferee. Now, presentment warranties states that any person who presents an instrument for payment warrants several items. They warrant that she's entitled to enforce the instrument, that the instrument has not been altered, and she has no knowledge that the signature on the instrument is unauthorized. Now, these warranties are known as presentment warranties because they protect the party to whom the instrument is presented. There are defenses to a claim on a negotiable instrument. These defenses fall into two categories. The first is what we call universal defenses. And universal defenses are defenses to liability on a negotiable instrument that are valid against all holders, including holders in due course and any holder with the rights of a holder in due course. The first defense is forgery. Forgery of a maker or drawer's signature cannot bind the person whose name is used unless that person has somehow ratified the signature or has contributed to it through their own negligence. Fraud in the execution. A person whose signature is obtained through fraud or deception is not liable on the instrument unless reasonable inquiry would have revealed to the signer the nature and terms of the instrument. So if you are defrauded into executing a document, you are not liable on that document, that instrument. An alteration that changes the terms of the agreement between any two parties in any way. It's called a material alteration. Material alteration is a complete defense against the claims of an ordinary holder. Now, material alteration is a partial defense against a holder in due course only to the extent of the alteration, meaning the maker remains liable on the unaltered part of the obligation. Discharge in bankruptcy. Discharge is an absolute defense against the claims of any holder, including a holder in due course. Minority refers to minority is a defense to liability on an instrument to the same extent that it is a defense to contract liability. Illegality, any illegal act which would render a contract void under state law, is an absolute defense against the claims of a holder, including any holder in due course. Mental capacity, also any instrument made or issued by a person that has been adjudged to be mentally incompetent, is void and therefore unenforceable by any holder, including a holder in due course. And finally, extreme duress, any instrument that is signed and issued under immediate threat of force or violence is void and unenforceable by any holder, including holder in due course. Now, personal defenses are good against holders, but not against holders in due course. These are defenses that may be used to avoid payment to an ordinary holder, but not an HDC or a holder with the rights of an HDC. For instance, breach of contract or warranty. When there's a breach of the underlying contract for which the negotiable instrument was issued, the maker of a note can refuse to pay it, or the drawer of a check can order his bank to stop payment. Breach of warranty may also be claimed as a defense to liability on an instrument. So that's a defense that is good against the holder, but not against a holder in due course. Lack of consideration, or what we sometimes call failure of consideration. The absence of any consideration may constitute a defense in some cases, but again, only to holders and not to a later subsequent holder in due course. Fraud in the inducement, a person who issues a negotiable instrument based on false statements by another party will be able to avoid payment of the instrument unless the holder presenting the instrument for payment is an HDC. So if you were fraudulently induced to sign the agreement, you were signed the agreement only because of fraud, you have a claim against the party who defrauded you. You do not have a claim against any subsequent holder in due course of that instrument. Again, illegality, acts that render a contract voidable, create a defense against an ordinary holder, but not against an HDC. And finally, mental capacity. Any instrument issued by a mentally incompetent person is voidable, and this defense is personal in that if the person has not been declared mentally incompetent by a court. There are other personal defenses: discharge by payment or non-delivery of the instrument, unauthorized completion of an incomplete instrument, ordinary duress or undue influence. All of those are valid defenses against a holder, but not a holder in due course. Finally, the federal government limits HDC rights. FTC Rule 433 limits the rights of HDCs that purchase instruments arising out of consumer credit transactions. The instrument will itself contain notice of the Rule 433 limitation. And if the instrument lacks the statutory notice, the holder in due course retains all of its rights. There are different means to discharge an obligation found in a negotiable instrument. Liability on an instrument can be discharged as follows. Obviously, discharge by payment or by tender of payment. Discharge by cancellation. The holder of the note cancels it. Discharge by reacquisition. Discharge by impairment of recourse. All of those are means of discharging any liability on the document. Obviously, the one we're most interested in is discharge by payment or tender of payment. So in conclusion, what did we learn today? Liability can arise from a signature. Liability can arise from a breach of a warranty. And there are two basic types of defenses to a claim on a negotiable instrument. And there are different means to discharge an obligation found in a negotiable instrument. That's it. Thanks for listening.